Do you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. R011089, State versus Tommy Lopez Jr. Could I have parties announced for the record for the state?
Ashley Jones.
Defense.
Adam Flores, Your Honor.
And are there any applications in this case?
No, Your Honor.
All right, Mr. Lopez, I'm sorry, counsel, have you received all discovery?
Yes, Your Honor, I have.
Did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are waiving the habitual enhancement allegation.
Any objection?
No objection, Your Honor.
All right, Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. There are no applications. The state will take in consideration 2024 PF 10226. There's to be no contact with the complainant, and you are to agree to a civil protective order at the Justice Center. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor. On the protective order, it'd be for the time he's serving in prison, 2 years, I believe.
I'm not in charge of when he is to serve his time as it relates to the protective order. I'm just here to tell you, a part of your plea bargain agreement is he's to agree to the civil protective order. So has he already agreed to that?
Yes, Your Honor.
I'm sorry, Judge. My understanding, yes, is that he has agreed to it. Our complainant is going to be applying. And so there is a process that it goes along with that.
All right, so when you serve that, that is not under this court's jurisdiction. Do you understand? Did you, that's yes or no? Yes or no?
Yes, ma'am.
All right, did you understand that to be the entirety of your plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Yes, Your Honor, but we waive them, Your Honor.
All right. Then to the offense, how do you plea?
Yes, ma'am.
State, any evidence?
Yes, state offers State's Exhibit 1 and all attachments.
No objection, Your Honor.
All right, state, you may be excused.
Okay.
Did you review the waivers and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He takes responsibility, Your Honor, for his actions, Your Honor.
All right, what is, because this complainant came to, I guess, a homeless location to give his mother food. What is the mother's name?
Nora Vital.
I'm sorry, what?
Nora Vital.
You say Vital?
Mhm.
Vital?
Yeah.
And the first name Nora?
Nora.
All right, so why did this escalate to this point if he's just there to drop off food?
He just started on me. He
No.
wanted to fight with me.
No, what it says is the victim's son stated that the victim was there to drop off food to his mother, who is homeless. Victim stated he got into an argument with mom's boyfriend and his mother, which then escalated to the suspect repeatedly swinging a machete at him while chasing him. Victim stated that he picked up a skateboard nearby and used it to protect himself from being struck. So according to this, he's just there to give food to his mom who's
We
homeless.
were in the park. We had a barbecue. We were in the park. We were gonna do a barbecue.
So you're saying you're not homeless?
At the time, we were homeless.
All right, so you're saying all of this is not true, and the collection of one glass pipe that's in the police report, you're saying that's not true?
Well, Your Honor, he's pleading guilty because it's the best thing for his case, Your Honor. The complaint gave a contradictory statement to the DA, but he's willing to plead guilty to get the case over with, Your Honor.
All right, court is going to find you guilty, sentence you to 2 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money run concurrent. Take in consideration 2024 PF 10226. There's an affirmative finding of deadly weapon. There's to be no contact with John DeLeon. You agree to a civil protective order in the Family Justice Center. The court will note for the record that the defendant has previously agreed to that, and there's to be no contact with Nora Vital. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Did you sign the trial court certification?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
The courtroom comes to order as Judge Stephanie Boyd calls the case of the state versus Tommy Lopez Jr., immediately setting a formal and controlled tone. The parties announce their presence, and the judge confirms that discovery requirements have been met. From the outset, Judge Stephanie Boyd establishes authority by personally ensuring the defendant has reviewed and understood the indictment and all court admonishments. Each question is deliberate, and each answer is placed on the record. The seriousness of the charge is made unmistakably clear when Judge Stephanie Boyd explains that the defendant is charged with aggravated assault with a deadly weapon, a second-degree felony. She carefully outlines the punishment range, 2 to 20 years in prison and a possible fine, forcing the defendant to acknowledge the gravity of his situation. There is no dramatization, only the weight of reality pressing down in the courtroom. The plea agreement is then laid out in full detail. Judge Stephanie Boyd confirms that punishment will be assessed at 2 years in prison, accompanied by a $1,500 fine and an affirmative deadly weapon finding. She lists additional consequences, including strict no-contact orders and a required civil protective order. Each condition is reviewed, and the defendant repeatedly confirms his understanding, eliminating any ambiguity. When asked how he pleads, the defendant responds with a single word: guilty. With that plea, the courtroom tension shifts from uncertainty to inevitability. Judge Stephanie Boyd formally finds sufficient evidence, enters a guilty finding, and proceeds directly to sentencing. Defense counsel emphasizes that the defendant takes responsibility, but the structure of the plea leaves no room for deviation. Judge Stephanie Boyd sentences the defendant exactly as agreed: 2 years in prison, credit for time served, and the financial penalty. She reiterates the no-contact orders, reinforcing the protective measures already in place. The final phase underscores the lasting consequences. Because the plea bargain was followed and the right to appeal was waived, the defendant is told clearly that he cannot appeal the conviction. As a convicted felon, he is also permanently barred from possessing weapons or ammunition. The hearing concludes with a brief exchange of courtesy, but the impact is lasting. Judge Stephanie Boyd's calm delivery and precise rulings demonstrate how authority, procedure, and consequence converge in a sentencing hearing where justice is firmly and unmistakably served.